I
Okay.
can mute our microphone. It's no big deal.
Awesome. So yeah, please everyone, as Jim mentioned, mute your microphone and enter your questions through the chat feature, which you can find if you hover your mouse towards the bottom of your screen. You'll see a little thought bubble and the word chat underneath, and there you can type in your questions. We'll monitor those questions as we go along and get them answered for you. And if there are any questions after the presentation that come up, just email Jim, Amanda, or myself, and we'll get back to you to help clarify. So welcome and thank you for being here to listen to Jim Stewart speak about the Boat Storage Lien Act and how to use it. We will be recording the seminar as well and sending this recording and the PowerPoint presentation your way after. So I have the privilege to introduce our speaker, who many of you may know as he's a familiar face and an invaluable member of the MBIA team, having served as MBIA's general counsel for more than 20 years. Jim Stewart leads the Maritime and Recreational Boating Practice Group at Cott's St. Peter. He has spent more than 35 years in law with experience in yacht financing, vessel documentation, and the perfecting and collection of maritime liens, including preferred ship mortgages, representing landlords and tenants in the negotiation of commercial leases, handling the purchase and or sale of commercial and residential real estate, and assisting clients with environmental issues. He is also a pro at obtaining construction permits and bottomland leases from the state of Michigan. He also consults with clients on business management, corporate governance, joint ventures, asset and stock purchases and sales. And not only does he serve MBIA, but he's also legal counsel for the National Marine Lenders Association. Jim has helped MBIA with many legislative wins, including the passing of this Boat Storage Lien Act in 2016. And for his assistance, we say thank you, Jim, for all you do and for your time today. And we're excited to hear what you have to say. Welcome.
Thanks, Nikki, and thanks, Amanda, for inviting me. I want to thank the association generally. I think obviously this is a topic that a lot of marinas get involved with at some point in their process, where they have boats which are sitting at their facilities that they've been delinquent, and most of the time been delinquent for more than a year is when people start getting a little antsy and wondering if they're ever going to get paid or not. So this is probably a good topic, and this time of year might be a good time when things before the boating season starts here. So let's get started. First thing is I'll talk a little bit about the history. Back in historically, there was a garage keeper's lien which covered automobiles, airplanes, and boats. And basically for different types of products, it had a different criteria that liens would take priority on. And in this case, for boats, it basically was a lien holder could come to the marina and pay them $200, and that was much of the priority that the marina had. So at some point here in, I think it was 98 rather, the auto dealers revised the Garage Keepers Lien Act. And when they did, it only applied to automobiles. And so at that point, we as an association worked with the Michigan Bankers Association to develop the Marina and Boatyard Storage Lien Act. So the idea was that this is only applicable to vessels and storage of vessels at that point. So the next thing is when you read the act, there are certain limits of priority that are given. The idea being that if there is a lien holder, a bank who has a lien on a titled watercraft as an example, and you have a boat that's sitting at your yard and it's been there for some period of time and you want to foreclose on that lien, obviously the bank has a lien and they want to get paid as well. So the argument is there's a dispute between the limits of the priority. So what was done is there was a negotiation that took place, and what we have are these different levels that you look at in terms of the size of the boat. So if the boat's less than 27 feet, the priority is basically $5,000 or 20% of the fair market value of the watercraft. So, versus the $200 that we had previously in the Garage Keepers Lien Act. If the boat gets larger, the numbers get larger, obviously, up to anything greater than 60 feet, you have priority up to $90,000. Now, that can be increased if the work is done on more than one engine. For a lot of these larger boats, you might have two engines that you're doing repairs on, and therefore you can, in essence, double that number. It also can be decreased if some of the items are certain types of services that you're providing, particularly like cosmetic type things. The bankers were very concerned that people, were not just, throwing a coat of paint on a boat and then seeking to get priority of $5,000 or whatever it happened to be. So we have to look at the type of service that is being rendered. If it's a repair, is it just storage, those types of things. So we have to figure that out as we go forward. It's a possessory lien, meaning that you have to have possession of the boat in order to get the priority. So if you've let the boat leave your yard, you no longer have a possessory lien, and therefore you would not be in a position to enforce the lien under this act. Now, you might still have, depending on the circumstances, a maritime lien that you could enforce, but under this act, it has to be in your possession, so the boat has to still be sitting there. It covers storage, labor, materials, repairs, and maintenance services. So the normal things that you would do in terms of boat maintenance, specifically repairs and storage being the largest one, including the labor. You need to include a notice of lien in your storage contract, or you have to send notice to the boat owner and any prior lien holders before you can enforce the act. So the best way to protect yourself as a marina owner is to include a notice of lien in your storage contract. So when the customer signs that contract, they agree that you have a lien on that boat to the extent of this Boatyard and Storage Lien Act. In other words, if the lien's not specified in your contract, you can't enforce that lien against the prior lien holder until 30 days after the notice of lien is mailed and filed with them. So in other words, if you've got a situation where there's a bank involved and you decide you're going to go after the boat holder and you realize you don't have it in your storage contract, you have to first send notice to the prior lien holder and to the owner of the boat, and you have to wait 30 days before any of the storage that you've accumulated will take priority over that prior lien holder. So you want to make sure that you have the notice of lien in your storage contract in order to protect yourself. To enforce it, how do you go about doing that? When you get to enforce it, you need to notify the property owner and all prior lien holders that have a lien on the boat. You have to wait until default has taken place for at least 180 days. And as I say in the parenthetical there, 30 days from notice of the lien. So in other words, if you didn't have it in your storage contract, you have to wait at least 30 days at that point. If you had it in your storage contract, you have to wait for a default for at least 180 days. We came up with 180 days. It was, again, a negotiation with the bankers, but the idea was that we didn't necessarily want to have liens enforced immediately. And in most cases, these were situations where it's seasonal. Somebody, doesn't put their boat in the dock, but leaves it in winter storage. So at some point you realize, well, they're not going to take the boat back. It's been 180 days. We now are going to try to enforce it. So you need to mail notice of the default to the property owner, the Secretary of State, and all lien holders of record if known. When you do that, the Secretary of State will send you a notice of who the owner is and who any prior lien holders are. So once you send that notice to the Secretary of State and to the original who you think is the lien holder, the state will tell you who the actual lien holder are, and they'll tell you who the notice, who the owner of the boat is. If the vessel's titled in another state, you need to provide notice to the other state, obviously, to get that same information. Doesn't help you to send it to the Michigan Secretary of State if the boat's an Ohio registered boat. If it's federally documented, then you want to obtain an abstract of title from the U.S. Coast Guard. And I don't know how many people here deal with documented boats, but if you do, an abstract of title is like a notice of like a title search to determine who the owner of the watercraft is and whether there's any lien holders outstanding against it. So you get that same type of information that you would from the Secretary of State. Recently,
hey Jim, can I stop you for a second?
Sure.
We had a question from Larry. What should your notice of lien say on your storage contract?
Basically, I think if you just notify them that boats that are stay for any length of time, if they're in default, then you have a lien, a possessory lien under the Michigan Marina Boatyard and Storage Lien Act. And I think if you contact, I know the MBIA has a little package that they've sent out before to people, and I think that information should be included in there. If it's not, I'll make sure that it is, and we can get that off to anybody who's interested in what they need to say. So there's not much to it. It's just it basically just says that there is a notice of lien that's provided under the act as a possessory lien, and so the specific language it doesn't say in the act what specifically has to be said, as long as you notify them that they in fact have a lien. So if you don't know, and this was a recent change that was made in the last couple of years, if the owner can't determine due to the condition of the boat, or if the vessel doesn't show who the owner is by looking at your records, and if you can't find out from the Secretary of State, in some cases, the boats are so old that the Secretary of State records don't reflect it any longer. And so if that's the case, you can send notice to the person who delivered the vessel to the facility if that's known. So sometimes the person who delivers the boat to the facility is not necessarily the owner of the boat. They could be a master or an agent of the owner at that point. So that gives you at least another chance to send notice and to get the process moving. You need to
There's
publish.
one more question.
Yeah,
do you send it to the local Secretary of State?
No, there's a Secretary of State address that, again, in this material that you get from the MBIA will list where you need to send it to the Secretary of State. There's a specific address to send it to in Lansing. And then when you get to the point of selling the boat, you need to publish an advertisement of sale for 2 consecutive weeks in a newspaper of general circulation. And that's just in order to get the notice out there. Now here, and I don't know if anybody can read this form. It's kind of small as I loaded it on here. But this is what you get from the Secretary of State when you send it back to them. And you'll see actually at the bottom of this, there's the address that I just talked about, where it talks about in Lansing on, I can't read it here, whatever it is, some drive. But when you look at this form, this is what you get back from the Secretary of State. And it has the vessel name and MC number and type of vessel, et cetera, up in the corner. In the middle of this document, it indicates, according to the records, who the owner of the boat is. And then below that, it says any lien holders of that have a lien on the boat. So that's the form that you would get from the Secretary of State. You would then be able to verify whether you've already sent notice to the owner or whether the owner is a different person on this record compared to what you have. And then are there any lien holders that you need to send to? And I'll be honest, in many of these cases, there aren't lien holders, because oftentimes these are boats that the owners aren't very concerned with the boat. The boats have been sitting in the yard for years in many cases, and there often aren't lien holders outstanding. There's only, I think in all of the foreclosures that I've done, there's only a handful of times where there's actually lenders involved, and the boats have, what you would consider reasonable or good value to them. Now, this is the back side of the form. You have another question?
Another question, yeah, from Yvette. For documented vessels, once you obtain the abstract, can you process the vessel the same way as state registered vessels?
Yes, the answer is yes, and we'll get to that in a minute. But yes, you can, and you just have to keep track of all of the information that you've done, follow the procedures under the Michigan Act, and then proceed from there. The only thing that I'll point out is if the boat is subject to a preferred ship mortgage or to a preferred maritime lien, this act does not take the priority over that. So you would not be able to foreclose on those vessels if that were the case. But if there's no liens outstanding and there's no preferred mortgage shown on the record of the abstract, yes, you can proceed by sending notice to the owner and following the same steps and procedures that we followed here. And I'll touch base on that again a little bit later in the presentation.
One more question. Secretary of State first or notice to owner first?
Well, again, I think the question is whether you have it in your contract or not. If you have it in your contract that you have this priority lien, then what you do is you send it to the owner, and if you know of any lien holders, you can send it to the lien holders. But oftentimes you won't know if there's a lien holder until you send the notice to the owner and the Secretary of State. The Secretary of State will tell you who the lien holders are, and then you would send that notice out to the prior lien holders. So, and again, if I go back, I'm not sure how to go back in my thing here. Amanda, do you know how I can go back a screen? How do I
Probably
move
the
back?
back arrow, just the arrow.
Oh, there we go. Okay, thank you. So when you get this form again towards the end of the form, it indicates who any lien holders are. So when you get that, it'll indicate the lien holder and it'll have an address for the lien holder. That's who you would then send that notice to. When you get this form, send that notice out relatively quickly to the lien holder to get that process going. If you have not included it in your storage contract, you want to notify the lien holders as soon as possible, because your storage charges don't, take priority over their lien until 30 days after you've given them notice. So you want to give them notice as soon as possible. On the back of that form, like I was saying, this is the process that you have to file in order to get title to the boat at some point. It indicates here, the information about who the owners of the boat were, the process that you filed in terms of doing it, that you sent notice out, when you sent it by certified mail, all of the things that we're going to talk about here in terms of getting this done. You fill out all that information as to when you did it, when the auction took place, who the person was who received at the auction, bought it at the auction, and you then supply this to the Secretary of State. They will then issue a new title to the boat to that person who bought at the auction. So this is the process that you're going to follow to kind of make sure and fill out all this information correctly, send it to the Secretary of State, and they will then issue a new title. And this is the same process that we'll get to in a few minutes to answer the question about the documented boat that you would follow with respect to the documented boat. It's just you wouldn't be dealing with the Secretary of State. You're going to end up sending the same information to the Coast Guard and have the title transferred similarly. So the earlier we talked about the notice of lien, and that's the thing that's in your storage contract or that you send out as soon as you can to the lien holders and the boat owner. Once there's been a default taking place, you then send a notice of default to the party. And there are specific things that are required in that notice, and I've outlined them here. You have to state that the property is subject to a lien held by, I can't read my own writing there since my picture's in the way. Hold on one second. And then it's subject to held by the facility owner. So in essence, the marina has a lien subject to that. The statement that the facility owners claim indicating that the charge and the date of the notice, the amount of the charges that became due before the date of sale, and the date of the additional amounts will become due. So in other words, you give them an invoice to indicate, what's owed, how much is owed between now and the date of the sale, and how much would be any additional amounts will become due. A demand for payment of the charges within a specified time, not less than 30 days after the date the notice is delivered. So in other words, we want to get paid, provide payment as soon as possible to this address, and notify them where they need to send payment. The statement that the property will be sold if the claim is not paid within the time specified in the notice, and the statement must include the time and location of the sale. So at that point, you'll know that you're going to sell it. Likely, you'll sell it at the facility at your marina. You'll like we said, have this notice in the newspaper that indicates where it's going to be sold and when, and there'll be a time for the sale. And then you'll have the name and address of the facility owner or your designated agent where you want anybody to contact somebody. So whether that's goes to you as the marina owner, or whether that goes to like my office if we were handling it for you, or if you had an agent who was going to handle it for you.
Hey, Jim.
Yep.
I don't know if you're going to address this, but there's a question. How about home built or untitled boats?
Home build untitled boats. Well, that's a good question. I don't, since the Secretary of State is not in a position to give you a title to that. I've not had that question before, so I'm not sure what the answer would be. I mean, how many of those do we have, I guess, out there? Maybe somebody can respond to that, and we'll try to answer that in a few minutes.
We can do some research and contact the Secretary of State's office as well for guidance on that.
Right. Yeah. So as we enforce this, after these 30 days, we publish the advertisement for 2 consecutive weeks in newspapers of general circulation. The date of the sale shall be not less than 15 days after the date of the advertisement of sale is first published. You have to sell it at a commercially reasonable public sale, meaning you can't sell it to your brother-in-law and tell him, hey, on the QT, come on out and purchase this and et cetera. It has to be a commercially reasonable sale, or else the boat owner would have a claim against the facility if they were to violate that. All notices should be sent registered or certified mail, return receipt requested. And the reason for that is sometimes you'll get back these receipts, these green cards that indicate that the owner isn't at that address anymore, but that's the last address the Secretary of State had for those people. And so when you send in that back of that form that I showed you, you send in the card that shows that you tried to notify them at that last address, and the Secretary of State will take that as you did what you can do to try to notify the owner. And the facility owner can bid all or any portion of the claim at the auction. And that becomes important because in the original act that we talked about historically, the garage keeper's lien, if the facility owner bought the vessel at the sale, they were deemed to have purchased it for the fair market value of that product. So if you were owed $2,000 as an example, and the boat was worth $8,000, you were deemed to have bought it for $8,000, and you had to pay the difference between the 2 and the 8 to the boat owner. Under the new act that we've put in place, which isn't so new anymore, but it allows you to build a portion of your claim or all of your claim at the auction. And, if you buy it, you get it at whatever you paid for it. And if there's a deficiency, that deficiency is what the boat owner would owe you at that point, and you would not owe them for that difference.
Jim, I have a few questions here.
Yep,
Can
go
I
ahead.
stop you? What do you do if no one purchases the boat?
Well, generally, the facility owner is going to want to buy it themselves for some portion of the claim that they have. Because the reason that most of the marina owners that I have worked with want to foreclose these boats is they want to get rid of them. The boat's an old boat. It's sitting in their yard. I've had some where the people have plants growing out of the boat. I've had ones that, there's holes and et cetera in them. They're old wooden boats that are rotted. And so you want to bid in yourself at the auction, and you become the owner. And then once you're the owner, you can do what you want with the boat. In other words, you can cut it up, get rid of it, do whatever you need to do at that point to get rid of it. On the other hand, if the boat's worth something, as in my scenario earlier where I said you were owed $2,000 and the boat's worth $8,000, you might want somebody to bid at that auction because you want to get your $2,000 out of the boat. And the hope is that the boat's worth something so you can get your money, and you don't care whether they pay $3,000 or $8,000 for it. They get the boat and they leave and we'll get to that in a minute, they leave your yard and you get your $2,000 that you're owed. So it really depends on the circumstances, but if nobody bids, you're going to probably want to bid yourself to become the owner so you can do what you want with the boat. More questions, Amanda?
It looks like there were a couple other that have no secured party when you do a Secretary of State lookup and vessels left on the property without contracts.
Okay. Well,
so is that kind of along the same lines as what you need to kind of look up?
Well, yeah, I think the question is if the boat's there and there's no contract, do you have an MC number for the boat? Do you have an official number for the boat? Do you have a whole number that you can identify the boat? Because those identifiers you can use to contact the Secretary of State to try to see if the boat's in fact titled, and then who the owner would be and whether there's any lien holders at that point. If you can't find out any of that information, as we indicated in the earlier slide, you can simply contact the Secretary of State and send notice to the prior person who dropped the boat off at your location, if you know that. Now, again, sometimes you won't know that because the boat, let's say you just bought the marina and the boat was there when you bought and there's no records to show who dropped the boat off or anything of that nature at that point, then you're not in that kind of position to do that. But if you can find any information about the boat that you can identify it and contact the Secretary of State to find out more information as to who the owner might be. Okay. What was the other question, Amanda? I'm sorry.
There's a few more now. This is from Linda. I have a customer that owes one company for services and he stores and docks at a sister company. The sister company has a different name and separate tax ID. There is common ownership. Can the repair facility that does not have possession still file?
Well, I would say no, that the issue is it talks about the facility owner. So I would think that the fact that you're not owned by even though the ultimate owner is the same party, I think you would have to foreclose your lien for the repairs separately from the storage and dockage that you mentioned earlier. So I think you have to treat them separately. Now, you may be able to, in that scenario, let's say the person brings the boat back to have repairs done like the next season, and you're now holding the boat for repairs at that point, you might still have your claim for the amounts that you were owed a year ago added to what's owed on the current amount to try to foreclose on that to get the larger amount included.
Okay. Going back to the scenario of the marina buying a boat, who would they be buying it from and who would get the money?
Well, if I understand the question, when at the auction, what's going to happen is you're going to purchase by bidding at the auction. So let's say that you have a boat which is in poor shape, not worth, let's say it's worth $100, and you're owed $2,000 for storage. You send all your notices, you do all the things, you get to the point of having an auction, and at the auction, you now bid whatever you want. Say you bid $500 at the auction. Well, in essence, you're going to pay yourself $500 because you're owed up to $2,000. So at that point, you pay yourself the $500. You then send all the information to the Secretary of State. You become the title holder to the boat because the Secretary of State issues you a new title. So in your question, it comes from the Secretary of State, and you then can do what you want with the boat, and many times simply destroy the boat and cut it into pieces and get rid of it at that point, because that's what happens. But you're really not getting any additional money, so it's not like the government's paying you to the $500. You're basically paying yourself the money for that. And in that case, maybe you only bid $100, or maybe you only bid $1, or whatever. But you're really just paying yourself for if you're buying it at the auction.
Okay. Does the boat need to have a starting amount at the auction?
No, as long as it's a commercially reasonable sale, it doesn't. It's not like there's a reserve price or something like you hear in other auctions.
All right, one more and then we'll move on. If a boat is trash and you just want to get rid of it, do you still have to title and facility name and pay the sales tax?
Well, I think the question is yes, because you want to get it in your name to be able to do what you want to do with the boat. Now again, remember, you can bid all or part of the claim. So if no one shows up, you could bid very little for the value of the boat and end up getting title to it at that point. And to be honest, I'm trying to remember. I'm not sure that you're going to pay any sales tax on the transfer that the state takes for a garage keeper's transaction. So it would really be the next when you sell the boat, then if there's any value to it, but presumably there's no value to it, so there wouldn't be any fair market value to assess sales tax against anyway. More questions?
All right, that's it for now.
Okay. So we'll going back to the outline. If the proceeds of the sale are not sufficient to satisfy the property owner's obligations to you as a marina owner or to the lien holder, let's say that there's a lien holder, then the property owner remains liable to you and the lien holder for any deficiency. So in my scenario, if you sell the boat for $2,000 and there's a lien on it for $4,000, and you guys take the first $2,000 because of your garage keeper or Boatyard Storage Lien Act, they still owe money to the lien holder, the bank at that point for the balance. And as we mentioned earlier, it doesn't cover documented boats with the preferred mortgage or maritime liens. And it does cover boats from other states, but you need to receive that information from the other state. And some states are more cooperative than others in terms of providing that information. So I can't tell you that every state who you deal with is going to be very cooperative to send you that information, but we have successfully done it with a number of states. At some point, the Secretary of State will issue you a new title or registration to the purchased boat at the sale conducted. If the vessel or trailer was from another state, the Secretary of State will notify the other state that a new registration has been issued. So in other words, you don't have to do anything with the other state because obviously you're here in Michigan. So we would issue it through the Secretary of State here, and you would get a new title and a new registration for the vessel here in Michigan. Here's where we talk about if it's a documented vessel. If it's a documented vessel and it's sold pursuant to this act, the facility owner shall there's a provision that covers this under the Coast Guard regulations. and you need to provide these items. A copy of the act. So you have to send a copy of the act to the Coast Guard that indicates the Boatyard Storage Lien Act. You have to have an affidavit from the property owner, facility owner, setting forth the grounds for selling it and the steps taken to comply with the act. So that's the same information that's on that back side of the Secretary of State form that you give. You have to have evidence of substantial compliance with the act. Again, you have to make sure that you send the notices, get the return receipts, those types of things. And you provide them with a bill of sale in recordable form from the facility owner as agent for the property. So in other words, you send into the Coast Guard a bill of sale that says, we, Marina, as agent for whoever the owner was, sell the boat pursuant to the Michigan Boatyard Storage Lien Act to whether that's the marina or whether that's a third party. And then the Coast Guard will take that and will issue, in essence, the bill of sale will be recorded with the Coast Guard at that point. A lien under this act terminates if the facility owner basically gets paid by either the property owner or a lien holder. So if a bank were to come in when you send them that notice and they come in and pay you what you're owed, then obviously your lien goes away at that point. Whether that's the property owner does that or whether that's a prior lien holder that does that. And basically, upon payment by a lien holder of record, you agree that you're holding the boat then for the lien holder, and you should not deliver the possession of the property to the property owner. So unless the facility owner and the lien holder enter into a new agreement, the lien holder shall arrange removal of the property from the facility. So in other words, if a bank comes in and pays you off, they should move the boat out of your facility or agree to a new storage contract with you that the boat's going to continue to stay at your facility. This last one, I just point out in the last year, we've done some of these for a couple of clients, and it takes a lot longer than it used to in order to do this because of COVID. When you contact the Secretary of State, there's a lag to get the information from the Secretary of State. When you send in all of the information, it used to be that you would, let's say within 30 days, get your title. It now might take 90 days to get your title to it. So if you're starting right now in the process, you may not actually get title to the boats until sometime in the fall, just because of the process that this takes. And by the time the Secretary of State follows through and gets all the information to you, and you follow all of the 30 days notice and the 2 weeks, for advertisements and things of that nature. So as always, we all want smooth sailing. Hopefully, we've given you a little bit of information to think about. And are there any more questions, Amanda?
Yes. Two-part question. If the marina is owed $2,000 and the winning bid is $5,000, does the marina return the difference to the old owner? And if the winning bidder does not pay at the end of the auction, can the marina assert its credit bid and take ownership?
Yes, usually the question would be yes. In the second case, if the person doesn't pay you at the time of the auction, then obviously you would go to the next bid, which could be another bidder, or it could be you as a credit bid that you would have. What was the first part of the question?
If the marina is owed $2,000 and the winning bid is $5,000, does the marina return the difference to the old owner?
Yes, if you're only owed $2,000 and you get paid $5,000, you would pay the additional $3,000 first to another lien holder if there is one, or to the property owner if there's not.
Gotcha. Can you hold the auction before receiving the bill of sale from the Secretary of State? If so, can the new owner take possession?
Well, no, you can't hold you can't give the bill of sale before the auction. Is that what it said?
Can you hold the auction before receiving the bill of sale from the
Oh, yeah,
secretary?
you have to hold the auction before the bill of sale, because the information that you provide on the back of this form that I showed earlier includes all of the information, including the auction date and who bought at the auction. That gets supplied to the Secretary of State, who then provides you with the new title to the boat. So, and if you're talking about a documented boat, you would have the auction so you could fill out the information on that bill of sale that we talked about that would indicate that you were selling it as the facility owner on behalf of the property owner to either the marina or to a prior auction purchaser. And so you would have to have the auction before that information would be provided to either the Secretary of State or the Coast Guard.
What about service performed on a boat that is not in your possession? How do you put a lien on that boat?
Well, you don't as such, because at least under this act, the act is, again, as I said, it's a possessory lien. Technically, you would have a maritime lien to the extent that you provide repairs or services to a boat, and you could enforce that maritime lien at that point. However, I will point out that depending on what work was done, maritime lien enforcement is much more expensive than the process that we're talking about here, where you're sending some letters and waiting some time. In the maritime lien foreclosure, you have to file an action against the boat in U.S. District Court, and you're going to need to get a lawyer involved to do that. So it's going to be a lot more expensive.
Okay. What is the next step if the winning bid is less than what the marina is owed?
Well, I guess the question is, what if you're actually doing an auction and it's a commercially reasonable sale? My gut reaction, my advice would be take what you can get, because if you've done your job and you've advertised the sale and you can only get $3,000 for it, even if you're owed $4,000, take the $3,000, and let the person get rid of the boat, because most of the time, as I said, marinas just want to get rid of these. In most cases, the boats are just eyesores, and they're taking up space that they could, give to customers who are paying them. So oftentimes you want to get rid of the boat and get it moved out. The other argument, and we didn't talk about this, but obviously at any point you can agree to settle with the property owner. So you can send your notice out to the property owner. The property owner can come back to you and say, hey, I don't agree that I owe you $5,000, but I'll pay you $3,500 right now and remove the boat from your yard. And you might be happy to just say, hey, let's just take the $3,500. I don't want to have to go through the process of doing the garage keeper, the Boatyard Storage Lien Act provisions, and I'll just take the $1,500 hit and go on my merry way. And but I would oftentimes in that case push back on to make sure that they get the boat out of the yard, because a lot of times people will owe, let's say they owe you $10,000, and they'll say, oh, well, I'll pay you $5,000 and I'll get the boat out of there. And then they pay you $5,000, but the boat just still sits there for another year or 2 years. And now you got 5,000 of the 10, so you're only owed 5, but you didn't get rid of the boat. And as I say, sometimes getting rid of the boat is as important to the marina as the actual dollars that they're owed.
Next one. What if no one bids on the vessel? Does the title go automatically to the marina, or do they have to put a bid in?
No, you would have to reflect the fact that you put in a credit bid at that point. But again, you can bid all or part of the amount that you're owed. So, you could simply bid, if you're owed 5,000, you could bid 1,000 and get the boat for that, or 100, or, whatever it would be. So, if nobody shows, sometimes when nobody shows, it's because people realize the boat's not worth a lot. And so that's just what happens.
All right. We have issues at times with the local Secretary of State not wanting to accept the BDVR 157 if the auction buyer does not reside in Michigan. Not sure why, but Secretary of State does not like to give title and registration to an out-of-state buyer, even if the out-of-state buyer uses the boat entirely in Michigan. What are your thoughts?
That's an interesting question as well. I guess I know we've talked before. We recently dealt with the issue of the boats from outside of Michigan that are at yards and dealing with that situation. But I guess I haven't seen where the person that buys it at the auction isn't a Michigan resident. Where the Secretary of State has pushed back. But I guess Nikki, perhaps we can follow through with the Secretary of State on that question.
Okay.
Absolutely. Yep, I marked it down. We'll follow through with that.
What about an abandoned trailer that has no serial number and no clue who owns it?
Boy, do we know who first delivered it there? I mean, I
Let's
don't
just
know
assume no.
or is it just, was it just an abandoned piece of equipment that somebody just left in your yard or something? If that's the case, you can contact the sheriff's department and indicate that it's just abandoned property. If it wasn't, something that was actually left with you for storage.
Okay. We have a vessel that we have searched in Secretary of State database and Maritime Registry with no results. How would process this vessel under abandonment? Is there a process to get Secretary of State to issue the title?
Well, again, I guess the question is, if we know who delivered the boat to them to begin with, we can contact that person as the property owner and follow the procedures that are set forth in the act. If, again, we don't know any more information about that and it's just abandoned at that stage, I guess the question is whether it was delivered to the facility at some point for storage, or whether it was just abandoned by somebody just came in the middle of the night and left it there. So if it was the latter, again, I would contact the sheriff's department and indicate that it was just left there. If it was at the facility and you just can't track any of the information, at some point, it's just difficult to imagine, it must be an old boat at some point if there's no information, no hull number, no, information at all with respect to it.
Okay. When is the winning bidder from the auction allowed to take possession of the vessel? Is it after the BVR 157 comes back from the Secretary of State?
Yeah, well, when you say comes back, the Secretary of State will actually issue a title to the boat at that point. And when that occurs, that's, the person will basically take possession at that point and will be the owner of the boat going forward.
What if you are having trouble getting information from other states? Is there another option to auction or dispose of the boat?
Not that I'm aware of. Again, we've been reasonably lucky in contacting a number of states. I mean, I've contacted some on the East Coast, and I know we've done some with, I think, Ohio and Indiana before in getting some information. So if you're having trouble, I would contact the MBIA and see if, perhaps we can, contact through the Secretary of State, see if they can, work with the Secretary of State and the other states.
Okay. Once the boat is sold at auction, is there a time frame in which the original owner could potentially pay what is owed and is allowed to retake possession before the boat is retitled to the new owner?
No, unlike what they're referring to would be like a right of redemption that you have in like a stock sale of a house or something, where you have a certain amount of time to come back and pay the taxes. They have the opportunity to redeem the boat prior to the auction. But once the auction has taken place, they've lost that right at that point, and the boat is basically gets titled in the new owner's name.
All right, next question. Our contract states there are daily storage fees for not paying or renewing contract. These fees can add up, especially after a year. Can Marina collect on the fees owed due to contract, or are we limited to the act charging by the size of vessel?
Repeat that question, Amanda, I'm sorry.
So it sounds like if there's fees related to storage, are they allowed to charge for the fees, or do they just get the value of the vessel?
I guess if you're talking about the things that we had at the beginning of our chart, hold on. Let me go back here. If you're talking about these items where we talk about if it's under 27 feet and the 5,000, or 20% of the fair market value, that provision, that relates to the priority between the facility owner and a prior lien holder as to the priority of the lien. So if you're talking about, having certain fees or charges that you have, you can collect your storage charges and, fees if you have a, interest charge that you're accruing with respect to the amount that's owed, or if there's a daily charge or something that you have for a certain amount, you could try to collect the amount that you're owed in terms of the storage. But if there's a prior lien holder, you're limited here with respect to what the prior lien holder, they have the ability to come in and take priority for anything other than the numbers that we're looking at there.
Is it possible to share our process and contract for review and recommendation? That's with you, Jim, right?
Yes.
And one more. If the boat came in for service and was never picked up again or service paid, they would not have a signed contract. We can still file, but just have to wait longer as we have to contact the owner first, correct?
Correct. Yes.
Okay, does anybody else have any questions?
Okay, awesome. Thank you so much, Jim. That was awesome. A lot of information there. If any other questions come up after this presentation, just shoot them our way and we'll do our best to get them answered for you. I'll follow up with the Secretary of State's office on a couple of these. Again, the session is recorded. We will send a link to that for you and also a link to the PowerPoint presentation. And then we have, as Jim mentioned, a packet of information regarding these processes, sample letters, and other helpful documents that we'll also send your way. So you can have those on file. I think they're located on our website, but I'm not sure where right now, but we'll send that to you as well. And other than that, I want to thank you all for being here and wish we could all be together in person. Nice to see some of your faces and your names. So hopefully next year or sooner than that, we'll all be able to do these types of sessions in person again. So Jim, safe travels to you. I know you're headed to the airport to go to Florida. Enjoy, bring back some weather.
Hopefully,
and, yeah. And
well, thank you. Thanks, everybody.
Thank you.
Thank you.
Bye.